Can I take a minute to respond?
Sure, and then I'm going to recognize Senator Lee.
Senator, a couple things on that. I pointed out in the South Carolina opinion, I wrote the majority opinion, that we see on an all too common basis that racism still exists in the United States of America. The long march for racial equality is not over. I cited, I think you've seen, after an African-American hockey player scored the winning goal, and a burst of racial commentary about him, and that was just one of many examples I could have cited in that case.
Racial commentary, can you be more specific?
Okay. Racist. I should have said racist. Racist comments is what I should have said online. And that was just one example I pointed to say the reality, just one example. I made clear that the reasonable impediment provision had to be rewritten. I was all over the real world effects during the trial that you're raising here. I was all over that. So were the other judges, of how's this really going to work in practice? How's it we drilled down and drilled down and drilled down and caused the rewriting of the reasonable impediment provision to make sure. I talked about the fact, for example, that African Americans in South Carolina at that time didn't have as many cars on the same percentage, and so to get to your point about getting the photo IDs, I made clear that I understood that. We blocked implementation for 2012 because we were worried, to your point about the form, that it wouldn't be enough time to get all this in place and to educate people. It was a unanimous decision. Again, neither side. The Obama Justice Department did not appeal our decision to the Supreme Court. I assume that's because they thought our decision appropriately accommodated the interests of the parties in that case and would ensure that African Americans in South Carolina were able to vote on the same basis as before. And talking about my life and record, and you were talking about that, going back to growing up, but the law journal note that I wrote on race discrimination talked about something that I know you've been talking about a lot, which was bias in the criminal justice system. And I said at the end of that law journal note that both racial equality and the appearance of racial equality were critical to the fairness of the racial justice system. I provided specific mechanisms for rooting out race discrimination in the jury selection process, and talked about what you've talked about, implicit bias or subconscious racism. I specifically talked about that in that decision. I've been I think, a leader. So there's a 2010 testimony before the Congress about the lack of minority law clerk hiring at the Supreme Court, and Justice Thomas and Justice Breyer were testifying before the Appropriations Committee, and they were asked about minority law clerks and the lack of them at the Supreme Court. And they said, in essence, well, we're hiring from the lower courts. And I remember reading that and thinking, well, I need to do something about that. I'm the lower court. I'm one of them. And so after that, I thought, what can I do? And I didn't just sit there. I went and thought, what can I do? And I started on my own going to the Yale Black Law Students Association every year starting in 2012. I think I'm the only judge who's done something like that, or certainly one of the few. And I just cold emailed them and said, I'd like to come speak about minority law clerk hiring because I'm told there's a problem there. And I showed up the first time wondering how it would go, and I explained, and I got a good crowd from the Black Law Students Association. I said, we need more law clerks. There's a problem, and let me tell you how to do it. And here's why you should clerk, and here's how you clerk, and here's how you, here are the classes you should take, and here's the things you need. And at the end of that meeting, I gave them my phone number and email and said, call me anytime, email me anytime if you want help. And then it was a big success. I got a lot of emails after that. I helped students get clerkships with other judges. One of them recently finished at the Supreme Court, emailed me thanking me for starting him on that road. And then it was a success, and I've gone back almost every year there. And as you know, we're graduates of the same law school. That's a lot of people clerk from there, so it's a good place to go. And I've continued to encourage African-American law clerks, but it's not just encouragement. I've given them help and advice and been a source of counsel. I've tried to be. And why is that? Because I saw a problem to the extent of the kind you're talking about. And it's one small thing, I suppose, but those are the future people who are going to be sitting around here and sitting here, I think. Those are the pool. And I've tried to be very proactive on that, including my own clerk hiring, where the old networks that prevented women and African and minorities from getting law clerkships. I've been very aggressive about trying to break down those barriers and be very proactive on that, recognizing that part of this is professors who have research assistants. And so I've done, my cases like the E.C. Ito case and the Ortiz-Diaz case, and I think the South Carolina case, I understand your concern about it, but I'm proud of what we did in that case. So I think if you look at your broader question about my life and my record, I understand what you're asking about a few comments in the Hawaii case. But if you look at the sweep of it, I hope it gives you confidence that I at least done my best to try to understand the real world and tried through my actual decisions to understand the real world and apply the law fairly, and through my other role as a judge and hiring law clerks to be very proactive in trying to advance equality for African Americans.